I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are stomping our boots into number 269 on our compilation list. For this compilation, please do not forget to like, comment, share, and subscribe. It is appreciated and much needed. We will be in 3 different judges' courtrooms. Commentary will be left in if there were any commentary previously. Chapters also will be added for your convenience. Now, the judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge Kolony Phyllis out of the state of Colorado. Second, we will be in the courtroom of Judge Kayla Wilcox out of the state of Washington. And last but not least, we will be in the courtroom of Judge Joseph Rossi out of the state of Michigan. As always, it is a pleasure to bring you this compilation, and now it is time to jump into 269.
This is 25M2378, People versus Alan Herrera.
Anders Erickson for the people.
Top of Mr. Herrera, right at the podium.
All right, so he was supposed to be here earlier this morning. Can you tell me what happened?
Thought his court date with that.
Position with regards to the warrant.
No objection to quashing it, Your Honor.
So given that he did appear today, I will quash the warrant, reinstate personal recognizance bond. We need to issue a mandatory protection order because I don't think one was ever issued in this matter. Let's see. So it looks like, Mr. Erickson, you want the listed victim protection order in boxes 1, 2, and 3. Is that correct?
Yes, Judge.
All right. So, Mr. Herrera, I am required to issue a mandatory protection order in this matter. It quite frankly should have been done a long time ago, but it looks like it was an oversight on behalf of the court. So I'm going to issue it today. It will list Margaret Kirshner as the listed victim or protected party. This protection order will state that you cannot harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts that you are charged with committing. You must also vacate the home or stay away from the home of any of the listed victims or witnesses. You must also avoid any stay away from or avoid any other location where they are likely to be found. And you must refrain from contacting or directly or indirectly communicating with any of the listed victims or witnesses. Do you understand those conditions?
Your Honor, it's I just want to say that I'm the beneficiary of my account, and before we can proceed with this matter, as director and beneficiary and executor of my own trust account, I have 21 days to show me a proof of claim of writing. They have jurisdiction to bother me at all. Until then, I do not consent to proceed. My next question is this a common law court? Because I represent myself under common law, or is this an admiralty court?
It's not an admiralty court.
And the day when the alleged allegations were created, I didn't see anybody. I was on the bike trail. Nobody was around me. So my question is, do you charge people when they are close to you, or do you charge them when they are far away? And people taking their own time to use accusations? Because this is what this ticket I'm being held here for something where I didn't see anybody. I got off the bike trail, but there was nobody around me, so there was people watching me. And to me, that's what I'm explaining about this.
So certainly, Mr. Herrera, I'm to talk with Ms. Nasri, and she can certainly answer any of those questions for you. All I'm asking at this point is whether or not you understand the conditions of that protection order. Do you understand those conditions?
Yeah, I comprehend. To stay away from the person, which I don't even know who she is, and yeah, I'll stay away and mind my business. Like I got no bill. I don't even know who the person is.
Okay, so knowing that you don't know who she is, it's not going to be an issue for you. It doesn't sound like so. That's a good thing. So we'll give you a copy of this order today. You're welcome to take a copy with you if you would like. You'll need to sign it before you go. And then you'll have time to talk with Miss Nazary further about this case, and she can certainly answer those questions that you have, okay?
And I just want to say I don't consent to the social experiment I'm going through. And that's just my situation. Everybody's case is different, but this is what I'm going through. And I believe President Donald Trump and other people been going through certain type of harassment through different ways, you know what I mean? But all I gotta say is if it's not intentional and I could face my accuser, then I'll try to make it right. But I'm here to show up for this, and for the record, I didn't know court was at 9:30, and I thought it was at 1, and I just rode just trying to get here, and I'm glad I made it at least. But thank you for your time. Thank you for your consideration, everybody.
You're welcome. So let me get you a new court date. Ms. Nazary, how far out do you want to set it? I can do June 15th or June 16th.
June 16th, that window.
Okay. So Mr. Herrera, I'll set you June 16th at 1:30. If you need a reminder slip, we can get that for you before you leave today. Otherwise, just make sure you stay in touch with Ms. Nazary. I will grant the request for a Bridges liaison as well, and she can talk to you about what that means, okay?
All right. Thank you, y'all, and have a blessed day. Thank you, y'all. Shalom.
Hold on, Mr. Herrera. Ms. Nazary's going to try, we're either going to do an order or she's going to try to get the eval from the other. All right, Mr. Herrera, take care. Have a good day, okay? They'll call you up in just a second, okay? Come on up, Mr. Herrera. Great, I think that takes care of our docket. Do you all have anything else? Okay.
Mr. Warren is here. He currently does not have an attorney appointed.
Mr. Warren. Mr. Warren, you want to come on up and, all right. You want to have a seat up here? Or would you rather stay where you are?
I'll stay here then.
Okay, that's fine. We can still hear you and communicate well. So we're taking up the case 24 on 130. And Mr. Warren, you've filed this motion to dismiss the state's charge. And I've had a chance we were together, I don't know, a few weeks ago, and we set this hearing. And so I'm going to turn to the state here. I don't have anything filed.
That's correct, Your Honor. And when I was reviewing this late last week, it came to my attention that nowhere in the record did the court authorize the defendant to proceed pro se. And the issue the state has is we haven't provided discovery to the defendant. We haven't provided discovery to counsel for the defendant. And until he's authorized by the court to go pro se, we can't really respond to his motion either.
Well, I think we're at a motion, and this was filed in February. And since April of 2024, it's been clear, Mr. Warren, who's also to us known as Mr. Azeltine, but Mr. Warren is proceeding representing himself. And he's made it very clear in his pleadings, and I'll allow that. And it's been allowed throughout. So are you going to respond to this motion today?
I can respond orally to the motion, Your Honor. Yes.
Okay.
I do have to express some hesitation and concern here, Your Honor. The state currently has a case coming back from a Superior Court appeal where the court did not go through the pro se properly with the defendant, and therefore the court is overturning that case.
Well, this goes back to filing of April 2024. I haven't looked through all of the recordings, but I think Mr. Warren, I think it's been clear that you're wanting to represent yourself since this beginning. Is that right?
Yeah, let me make that clear. Without recourse, as my unrebutted affidavit on file in this case stipulate, I am not the ends leeches, Mr. Asseltine. I'm not Mr. Warren. I'm a man. My mother called me Ty Warren, and I'm of the Asseltine family. Sovereign as spoken of in Yickwo versus Hopkins, and not the corporate artificial entity Ty Warren Asseltine in all capital letters, nor representing the defendant, Ty Warren Asseltine. I'm not here pro se. I'm here by special visitation, sui juris, in propria persona. You may call me Ty Warren.
Okay.
I'm here under duress and threat of arrest by special visitation, reserving all rights without prejudice under UCC 1-308, and refusing any contract not explicitly agreed to. For the record, I do not consent to the court's general jurisdiction over my person.
All right. So you're in a criminal court and you have the right to be represented by an attorney or to represent yourself, to speak for yourself, put it that way, and not have an attorney represent you. So where are you?
I'm here to present myself as a man,
Okay.
not as a corporate entity.
All right. And I think throughout, well, I know throughout, we've talked about this whole idea about appointing counsel or not, and we haven't done that because you didn't want that. And I remember the times that we've been together. I can't speak for any other judges without looking at their records or listening to their records. So, and the prosecutor's office has been here throughout the times that you've been before the court. And the last hearing, April 8th, was when we cleared up that warrant and we set this hearing. So it's abundantly clear, and that Ty Warren here is speaking for himself or representing himself, and we're going to go forward on that because we've had those discussions for over a year now.
Again, I'm not representing myself or the defendant.
Right, I understand. So I see in the pleadings that you filed that there's at least one. First thing that might be most dispositive is the motion to dismiss based on Court Rule 3.6, which is a suppression of evidence, saying that there was no basis in the law for you to be stopped by the officer. So we're going to start there. Well, I'll make the record here as to jurisdiction and venue. I think I've made that record already, and I don't see anything. I'll hear from the state if there's anything else. And we talked about this at the last hearing, that this is the district court. This is an allegation of a driving offense under RCW 61, also an allegation of obstructing law enforcement. Those are properly filed in this court as they're alleged to have occurred here in Thurston County. And this court has jurisdiction, subject matter, and in personam jurisdiction. So venue is proper as well. So
I'm here to challenge that.
I understand, and that's part of your motions. Just making the record that there isn't any basis in your motions that have undercut that reality. So the court does have jurisdiction and venue is proper. So we're gonna hit that 3-6 motion. And I'm going to hear from the state as to what evidence they have to present. And I'm looking back to that motion. I think it's about 33 pages. It was filed back in February and reiterated throughout. So Mr. Thompson.
You're speaking of my affidavit.
Yes. And you've filed a lot of information. I've taken it all together. It starts out with that motion to dismiss from going back to, June of 2024. I misspoke.
You can sum it all up with my most recent affidavit.
Yeah, and that I'm also including in my reading, everything you filed. But so now I'm going to jump to the state because they're the ones who have to defend against your motion. I will hear more from you. So, Mr. Thompson.
Thank you, Your Honor. And The sworn statement that our office provided at the initial hearing stands that the defendant was stopped for speeding, and during the course, that was the basis of the stop was speeding.
And so resting on that initial probable cause finding in April.
That was, yes, correct. That was the basis for the initial stop, which would give rise to the Terry stop for an infraction. And from that point on, the defendant refused to give name and gave a world passport ID card or world passport. I don't even know how to fully describe it accurately, other than not a document from a government entity.
So anything you'd like to say more, Mr. Warren or Ty Warren?
Yeah, plenty to say.
As to that issue, let's kind of focus in on issue by issue.
What the prosecutor has just said. He stated that I did not give a name, and then he counteracted himself by saying I did give world passport ID, and then he said it was not a valid or whatever he said, and not valid or not recognized by the state. But whatever the case, I would like to present what I have to say here. I'm a man visiting here, especially not generally sui juris and deprived solely to challenge jurisdiction.
Let me ask you a quick question. Did you already file the information that you're reading?
No.
No, this is new?
Yes.
Okay. All right. You have an extra copy?
This is just my oral.
Okay. All right.
Printed out.
Let's see. Try and focus in on the motion to dismiss that you have for suppression of the evidence.
This is what this is all about. It's all about jurisdiction.
Well, we're not talking jurisdiction.
Proven on the record, and I have seen no proof of jurisdiction.
Talk to me about your motion to suppress. Talk to me about your allegation here.
I'm here to establish jurisdiction or not.
Well, I've already maybe I should be more clear.
There are no facts on the record.
I deny your motion as to jurisdiction in this court. So this court has jurisdiction and venue. What I need to hear from you is what do you have to say about your motion to dismiss for a bad stop?
I can't say anything about a motion to dismiss until jurisdiction has been established.
I've denied your motion. This is the correct court. We have jurisdiction, so move on. You can disagree with the court's order, but you can't make it better by just continuing to argue about it. So let's move on to that other motion that potentially is dispositive, the stop.
One moment, please.
Sure.
I respectfully object to that ruling and give notice. I contest the court's assertion of jurisdiction all the way. Let the record show that I timely and persistently challenge jurisdiction, and that challenge remains unanswered by factual evidence.
Anything else? Just looking back through your affidavit and your motion. Anything else for me to consider from you?
Like I said, I have plenty to consider.
Okay. About, first off, as to this motion dismissed based on the bad stop, is what you say.
Yeah. Excuse me?
Your motion to dismiss based on a lack of good reason for the stop. That's what I'm first dealing with.
I can't even address that issue without jurisdiction being established.
Okay. All right. Well, all right, Mr. Ty Warren, Mr. Azeltine, however you want to be referred to. So this is the deal. I'm granting your motion to suppress all evidence after a stop. I have no evidence presented that I can consider. This was filed by you in April of 2024. And there's been affidavits and information filed thereafter, all in the court file. We've set this for trial, or we've set this for motion as recently as April 8th. State was present. It's kind of like, for whatever reason, the state decided not to join or prosecute. So under Rule 3.6, I don't have any evidence to overcome what your assertion is that you were peacefully driving down the street. And simply the probable cause statement from the beginning to allow the set of release conditions is not sufficient. There isn't any thing in the court file, in the court record that would allow the state to overcome your motion to dismiss or motion to suppress evidence. So all evidence obtained, stat forward, is suppressed or not allowed to be brought forward in trial by the state against you. So with that ruling, Mr. Thompson, from the state's point of view.
I believe the court is, well, I have nothing to add, Your Honor. The state will be filing an appeal.
All right, so are you saying that with that order of suppression state, you're thinking an interlocutory appeal and able to go forward?
Yes, Your Honor.
Okay.
Well, I suspect the court intends to dismiss the case at this point. So I don't think an interlocutory appeal is what will happen, but an appeal nonetheless. You know, again, the state stands by its position that I put into the record regarding his appearance today pro se. I still do not believe that the court has gone through it properly. I will note one additional thing for the record, that in his motion to dismiss, he specifically says that he's doing so under duress, which calls into question the validity of any of his filings. And the reason why the state still believes, even over his objection, counsel should be appointed, because he is not here of his own free volition, as he said more than one occasion in more than one filing.
It's clear to the court he is throughout all of this. The semantics that he likes to use are not persuasive to the court. So, but as I said, the prosecution's decided, not to present. So, as we know, Mr. Azeltine, as we know you as, this matter is dismissed, given that suppression of all the evidence, and you're free to be on your way.
Thank you.
Thank you, sir.
Is Franthea Price, case number 25-05340AE. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court for a motion today, although it was not clear to me what the nature of the motion is. So as an initial matter, Ms. Price, would you state and spell your full name for the record, please?
I just want you to know, Your Honor, I'm here specially, not generally, and do so sui juris as the authorized agent for the Franthea family of the Price estate. So my appearance is strictly limited to the matter noted today, and it does not grant any joinder to general jurisdiction, nor does it have any waiver of rights or imply legal disability or association with any bar guild.
Well, I get it, Ms. Price. However, I can tell you that I'm a general jurisdiction court. I operate under the United States Constitution and the Michigan Constitution, and those are the only things that give me jurisdiction to act or make any decisions. So if you want me to decide anything in your case, you're going to have to be within the jurisdiction of my court. So, and we don't have to hammer that completely out at this time, but I do need you to state and spell your name.
Franthea, Franthea.
All right. Last name Price, Price?
I am.
Very good. And Mr. Bakukio, would you place your appearance on the record, please?
Thank you, Your Honor. May it please the court. Stephen Buquicchio, Buquicchio, P number 62076, on behalf of the plaintiff preferred credit union.
Very good. And Mr. Bakukio, this is not your motion. This is Ms. Price's motion.
It is, Your Honor, although like you, I'm a bit confused as to what the relief she's seeking here. So I'm prepared to assert preferred's position legally here, and we'll wait for the court's direction as to when I can speak on that.
Very good. Well, let me go back to Ms. Price, because it's her that, initiated this motion appearance. What are you asking me to do at this time, Ms. Price, in a legal sense?
I respectfully request that the court take judicial notice pursuant to MRE 201B of the following two documents I previously filed into the court record. One is Exhibit J, OC 10, subpoena duces tecum, demand for custodial records. And number two, supplemental notice of clarification regarding the constructive subpoena duces tecum. These materials, Your Honor, are supported by the Federal Reserve Operating Circular number 10, Appendix 3, UCC Article 8, subsections 8, 102A, 14, and 15, 12 CFR, subsections 225 and 31 CFR, subsection 203, which
Let
collectively.
me just pause you just a minute, Ms. Price. The one thing I recognized of everything you said there was the Michigan Rules of Evidence and the term subpoena duces tecum, meaning you're directing a discovery subpoena. Is that directed at Preferred Credit Union?
It is, sir. I also wanted it to be on record because I previously asked for debt validation and didn't get anything in the lower courts. So
Okay.
Your
Well,
Honor, may I respond?
Yeah, go ahead, Mr. Mercutio.
Couple things, Your Honor. There's a lot to unpack there. Number one, we have a judgment in this case. So any attempt for discovery is outside, respectfully, the jurisdiction of this court at this point. I suspect what Ms. Price or the estate of Ms. Price or the Franthea Price family of Price estate is seeking to do here, Your Honor, is undo the judgment that was legally entered in the lower court case. So I would just say, Your Honor, what she's asking for is irrelevant and outside the bounds of what this court can do. The case is over as far as the district court is concerned. I can get into the argument as to the debt validation. I did produce with our response a motion for summary disposition there that did provide for the debt validation notice. Ms. Price continues to mislead the lower court and now this court that a debt validation was not given. It was in fact given. This is a simple credit card case, and she is trying to use far-flung, just I can't even characterize what these arguments are, Your Honor. I want to be respectful of Ms. Price's ability to defend this in pro per. But
I object, sir. I'm not in pro per. I'm sui juris. Thank you.
Okay, whatever that means, Your Honor, this is making a $12,000 credit card case so much more for my client, and Ms. Price, pursuant to the agreement, is responsible for those attorney fees. And I know there's a fine line between allowing a defendant in pro per or sui juris or whatever the name she's calling it, but this is just abuse of the process, Your Honor. She is alleging things that have no legal bearing whatsoever. She's asserting UCC, bill of cost, bill of ladings, bill of exchange, foreign bill of exchange. Your Honor, I don't even know what this means, to be quite honest, and I've been doing this for over 25 years.
Let me just pause you for a minute, Mr. Mercutio. Something I did see that I did recognize as I paged through the file was the affidavit of a transcript of the lower court record, which is normally produced in a case that comes before me on appeal of the district court decision. Are you aware of a notice of appeal filed?
I am not aware of that, Your Honor. I suspect what was done here, Your Honor, was in the lower court. The judge indicated to Ms. Price that she's ruling in favor of preferred, and she was welcome to appeal that. And I suspect this is her attempt to appeal that. And to the extent Your Honor is ready to rule on her appeal and either, overturn the lower court's decision on the judgment or some other ruling here, I'm going to proceed as though she is seeking to undo the judgment that was entered against her. That's all I can surmise by this, Your Honor.
Yeah, if I may speak.
Yep, go ahead, Ms.
I
Price.
believe the opposing counsel has stated he has not received an appeal. I have sent that, all the information you received. He's received that. I have the record that the hard copy receipt from the post office. I sent this certified mail. So I do have the receipts of all of those things. Whatever you have, his office received it as well. I do have the proof of service and all that. The fact of the matter that he continues to mischaracterize this as solely a simple credit card debt that I'm trying to avoid, that is simply a mischaracterization of what I'm attempting to do, as is unsupported on the record that I've attempted through bill of exchange, and I've asked and requested and have not received a simple application. A copy of it is not supported of the verification that this is a bona fide contract, and lawful consideration, if it's not done, is violation of a contract as well.
All right. Well, here's my where I sit on this one, Ms. Price, is that my position legally here is I'm the court of I can sit as the Court of Appeals to review the judgment in the district court. And what I appear to have in front of me here is a partial appeal, in that I do have the record, at least at what looks like to me. It's not a full record. It's just the transcript of the summary judgment hearing at the in the district court in Kentwood. Normally, when I get the record from them, it has a whole bunch of other documents that explain, in a nutshell, how that case was reduced to judgment. And I don't have that, so I don't appear to have an entire record. And what I don't have from you specifically is a document called a notice of appeal that tells me that you're appealing a final judgment and that you want me to review that for its legality. I can tell you, because it is on appeal, it follows the appellate rules of the Michigan court rules, and they are, for lack of a better term, more intricate and harder to follow than the general court rules or the court rules for proceeding in the district court or in the circuit court. There are a lot more hoops to jump through on appeal, and that's really where you are when you're in front of me. And I can also tell you that on appeal, what I'm supposed to do is look at the record that was generated in front of Judge Sturkenberg, and the new stuff that you file with me, arguments or requests for discovery. Mr. Bequicchio is accurate in saying that normally you don't get any additional discovery on appeal. Normally what you do is you make an argument on what happened below, and that might include that Judge Sturkenberg denied you proper discovery, and that thus she made a legal error that warrants me overturning that case or sending it back to Judge Sturkenberg for more work or things of that nature. And I can tell you, from what I see in the file right now, I don't have the information I would need to decide that. So what I am going to do is direct you to file the requisite notice of appeal and appeal documents within the next 15 days, or I will dismiss the appeal, and you'll have to start that process over again. And the dismissal may have a substantive effect on your ability to file another appeal. So what I'm telling you is this appeal that's in front of me right now is incomplete. It's not documented per the appellate rules, which are found in the Michigan court rules. And, I wouldn't have any choice but to dismiss it unless you supplement it with at least bare minimum a notice of appeal and sufficient information to inform me and Mr. Bequicchio what the nature of your appeal is. What it appears that you're appealing from a final judgment. However, all I saw in the final judgment, I think, was the fact that Judge Sturkenberg did grant that on the record. I didn't see. Do you have a judgment in order that you filed, Mr. Bequicchio, a written order in connection with that?
We do, Your Honor. A judgment was indeed entered subsequent to our motion for summary disposition and hearing on that motion, and I believe that was submitted with our response to Ms. Price's filing, whatever that was, Your Honor.
Okay, and unfortunately, I have Miss Price's filing. I don't think that I have your response. It didn't make its way to me in time to come home with me for the file. So I'll review that as well. But Miss Price, like I say, there is documentation. And it is strictly required by the appellate rules. There's no way, sometimes in the lower courts, a judge can say, well, you're appearing as a sui generis pro se, a lawyer, a person appearing without an attorney appearing beside them, and I can give you a break on following some of the rules. That's not true at all on appeal. Appeal there, either you follow the rules or your appeal gets dismissed. It's kind of a black and white system in that regard, and that it doesn't give me very much discretion when I'm sitting in that appellate jurisdiction. So you do need to get that in order, and I'm going to have it ordered that it be done within 15 days. And that's, I think, all we can do for today.
Your Honor, as a procedural clarification, Your Honor, to the extent Ms. Price does supplement her appellate filing and the court finds that it is inconsistent with the appellate rules, will another hearing be required, Your Honor, or
No, I'll just sign an order of dismissal if I don't have the proper documents to initiate the appeal.
Terrific. Thank you, Your Honor.
Very good.
Your Honor, you said I have 15 days to get the information because I believed I sent all of this stuff in appropriately. I went into and handed it in and got the proper documentation. And the fact that you said you don't have that information is a little
Yeah, no, I do have a bunch of
about it.
stuff that you filed that appears to have been printed out by you. The one thing I have, and the only suggestion I can make, Ms. Price, there is a legal assistance center on the 4th floor of the courthouse. If you talk to them and say, gee, Judge Rossi said I was missing some stuff on appeal, they can at least direct you to the proper forms to file to initiate an appeal. Because the one thing I did receive here was the notice of filing of transcript and affidavit of mailing, and that's on a Michigan court form that I recognize. And what I then got was a transcript of that hearing, the last hearing, it appears, in front of Judge Sturkenberg. However, there is more stuff. They need to, what really they need to do is transmit the entire record of that case, or you as the party need to assemble that record on appeal, the record of what happened in the lower court, and get it to me on appeal. And that basically looks like those transcripts plus any paper documents in the court file that happened in the district court. And I don't see any of those in my appellate file here.
They told me that I put there that they was going to mail it to you. They mailed me a copy and they said they was going to mail you a copy because I purchased the transcripts and everything.
Yeah, and I did get the transcript, the one, but that's just the transcript of the the hearing on appeal, and that is part of what I need. Well, and I said I didn't have a claim of appeal. I stand corrected as I'm paging through here. And I have to tell you, Ms. Price, the filing of the additional documents here, I know you believe it's important in helping me to decide your case, but I can tell you what it's doing in a practical sense is making it really hard for me to file, just to track the documents that actually do trigger my duty to decide stuff on appeal. So I do have a claim of appeal. Looks like it was signed by you on June the 13th of 2025. So really what I need on appeal then, and again, I'm also prohibited, as the folks at the Legal Aid Center are, from giving legal advice. But I can tell you, if I'm to decide any appeal, I'll need a copy of the entire lower court record on appeal. And the record on appeal, like I said, usually it's assembled by the parties to the appeal. Usually you, as the person, the individual appealing the decision of Judge Sturkenberg, are the one that's going to, put that together. Mr. Bequicchio can contribute to that record if he wishes to do so. And then that gets submitted to me, kind of as a here's what happened at the lower court. It tells the story of that in those filings and pleadings filed at the lower court. And then you file a brief on appeal, and your brief makes the arguments as to why Judge Sturkenberg made legal errors in her decision making. And, since I'm requesting that brief now, I just thought I was needing the claim of appeal. But since I have a claim of appeal that properly initiates the case on appeal, what I really need then is that record on the lower court, and then I need a brief from you explaining the errors that you think Judge Sturkenberg made. And I'll tell you, I will not be receptive to documents telling me that Judge Sturkenberg or I didn't have jurisdiction. That would be in effect saying, Judge, I'm arguing that neither of the courts could really decide this case because of my legal status, sui generis, or whatever magic words you're trying to invoke there. That just doesn't work. And the reason it doesn't work, particularly on appeal, is I have to have jurisdiction to decide the appeal in the first place. And if you're telling me I don't have jurisdiction, you're as good as telling me, as judge, dismiss my appeal because you can't decide it anyway. And so in other words, you got to give me more than that. It's got to be an argument based on Michigan law as to what mistakes were made by Judge Sturkenberg in the court below, and then I can decide the matter on appeal. And since I'm looking for the brief on appeal, that's a little harder to put together along with that whole record. I'll extend the time for the filing of the record on appeal and your brief on appeal. I'll give you 60 days from today's date. We're at July the
25th.
25th. Yeah, sorry, my glasses. I'm using a backup pair of glasses because my regular ones are in the shop. So 2 months from today will bring us to September 25th to have those documents filed. And then I'll be able to decide those. And I'll also tell you, Ms. Price, the way it works on appeal is I don't need to grant. You can request oral argument, which would be another version. Today, really, this is more of a status conference. It's not so much oral argument because I couldn't make head or tail of what the file was asking me to do. You can request oral argument if you want it. I don't have to grant it on appeal. Sometimes I just review the record and the filings and, decide the appeal based on that. And of course, Mr. Bequicchio, after that 60 days, can file whatever he wants in response to your arguments on appeal. And likely that'll be a motion to dismiss the appeal saying Judge Sturkenberg did everything right and there's nothing to look at here, folks. So that's kind of how it works on appeal, just for your information. And like I say, if you need help with at least the forms part of it, the Legal Assistance Center on the 4th floor of the courthouse is a good resource for that.
Okay, so am I, just for clarification, because I'm going to do this right this time, this coming next time. There's 60 days you need to brief on appeal explaining the errors of the lower court.
Correct. And the record.
And you need a complete record of the two hearings that had taken place.
I need the complete record from the lower court, and that would start with everything from Mr. Bequicchio's complaint that he served you with and the proof of service and all that stuff. Typically, there's a copy of it. Would be as if you grabbed the file from Kentwood and made a copy of every piece of paper in it.
Okay.
Plus the transcripts.
Okay. Plus, you still need the transcripts as well?
No, you already filed the transcript. If that was the only hearing in the case, were there other hearings?
There were none, Your Honor.
Okay, so that was the only time that you two argued in front of the judge. So I don't need any additional transcripts. I just need the record on appeal.
Your Honor, there may have been a pretrial. I can't remember whether or not that was on the record or not, Your Honor. But if it is indeed on the record, the lower court record would include that, of course.
Very good. All right, so that's what I need, is that record from the lower court. Mr. Bequicchio, I think the appellate rules allow you to weigh in and supplement the record or collaborate on submitting the record to me. I'll leave that to you. as to how much you're going to participate and assist with that production. But you two can talk to each other. The goal being to get everything in front of me that I need to decide the arguments that you make in that brief on appeal, which is where you get a chance to make your substantive argument as to any errors made by Judge Sturkenberg.
Thank you, Your Honor. I will say, to clarify from our position, we did respond to the filing of Ms. Price. With that, we included the complaint, the answer, and our motion for summary disposition, and Ms. Price's response to that motion for summary disposition. So that should make its way to the court file. I don't know whether that would be deemed an official record as far as the appeal is concerned with certified documents, but we did put the underlying materials in our response. So that will be contained in your file. And
Copy obviously went to Ms. Price, so she should have received
yes,
all those filings as well. And yeah, normally, right, there is the certified record on appeal gets a simple one-page document from the district court saying this is everything we have in our file. So I would accept either way. If you want to supplement what Mr. Bequicchio sent Ms. Price, or whether you want to just go to the district court and say, hey, I need a whole copy of that file because Judge Rossi's asking me for it, and it's got to be certified because it's on appeal. They at least have done that before down there at the Kentwood Clerk's office, so it'll at least give you a starting point as to what to do. And like I say, I think I'd make my first stop the Legal Assistance Center so you can walk in there with the right form when you go to Kentwood District Court.
Thank you. And then do I use the same case number as well?
No, it'll be assigned, and it already has been assigned a new case number on appeal, which is the one we're here on today. It's 25.
Yes, that number. That's the one I'm speaking of.
Yep, that is the appellate case number.
Okay.
Now, when you're talking to Kentwood and if you're looking for
It's
the
a different number.
record, then you got to
Yes.
go with that number down there.
Okay, thank you. I appreciate your help, sir.
Very good. Good luck to you, ma'am.
Thank you.
Thank you, Your Honor. Thank you, Ms. Price.
I'm not threatening you. Say one more word and that's 30 days. 30 days.